Deputy Registrar, would you please call the matter?
Good morning, President. Thank you. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Belize, hearing of appeal in CCJ appeal BZCV number 6 of 2025 between Rudolph Ramirez, Julius Zabaneh, and the Attorney General of Belize and the Minister of Natural Resources. The members of this morning's panel are Mr. Justice Anderson, President and Presiding Judge.
Good morning, Counsel.
Madam Justice Rajnath Lee.
Good morning, everyone.
Mr. Justice Jamada.
Good morning to everybody.
Madam Justice Ononiwu. Madam Justice Ononiwu, Judge, are you hearing us?
I am now hearing you. I had to change some settings on my computer. Good morning, everyone.
Thank you so much, Judge. And Mr. Justice Ebu Suji.
Good morning, everyone.
Counsel, may we have the appearances, please? Thank you.
Thank you. Good morning. Dean Barrow for the appellants, and together with me are Ms. Naima Barrow and Mr. William Lindo.
Thank you, Mr. Barrow.
May it please the court, Amon Courtney for the respondents. Appearing with me is Ms. Samantha Matut, Deputy Solicitor General.
Thank you, Mr. Courtney, and good morning again to you all. We are ready to hear the appeal in the matter called by the Deputy Registrar. I believe that the attorney for the appellants will go first for an hour. Call upon Mr. Barrow to proceed.
Thank you very much, Mr. President. Your Honors, this is an appeal dated 23rd December 2025. The notice of appeal appears at tab 1, I believe, of the record of appeal, and it's at pages 1 to 8 of the record. There are written submissions of the appellants, two sets of written submissions actually, at pages 765 to 779. The first set of written submissions is dated the 26th February 2026. The respondents filed written submissions dated 1st March 2026, and we, the appellants, did reply submissions, and those are dated the 27th March 2026, pages 1325 to 1331 of the record of appeal.
Thank you, Mr. Barrow, and I do notice, if I may say so, in commendation that you stayed within the limits which we had agreed. Thank you very much.
Thank you, Your Honor. I'm obliged to you. We, of course, rely on our written submissions. There's one point I need to make right at the start. My learned friend, Mr. Courtney, Senior Counsel, filed yesterday a speaking note. Now, my understanding is that there is a practice direction of this court that says that a speaking note, in order to be considered, must be filed not later than 3 days before the hearing of the appeal. I say again that my learned friend's speaking note was filed yesterday, so I would submit that, in fact, the court will not be entitled to consider it.
Mr. Barrow, could we come back to that issue before Mr. Courtney speaks?
So that I will proceed now, but just before
Yes,
Mr.
yes,
Courtney
as I meant.
speaks,
Yes.
you,
right.
Mr. President, will deal with that issue of the speaking note.
If we have to, yes.
Yes, obliged. Your Honor, I wonder if I could start then by sketching the background, the facts that constitute the provenance of this appeal. I think the starting point is the Belize High Court claim number 712 of 2021. And your honors will find that, I believe, at pages 78 to 114 of the record of appeal. Let me just find the tab number. It's tab 10 in the record of appeal. So, your honors, that claim of the appellants, then of course the claimants in the court of first instance, was, as your honors will see, for several reliefs. I'm sorry, was Mr. Justice Chamadar saying something? My apologies. May I
Apparently
continue?
not. Please proceed. Yes.
Thank you. And those remedies, as you will see, were for the following: an order for specific performance of a contract of sale in writing between the first claimant and the second defendant, made on or about the 5th day of September 2019, for the purchase of the freehold estate of some 14.76 acres of land, free from any encumbrance and/or defect. Further, or alternatively, general damages, being the market value of the 14.76 acres of land, for breach of the contract of sale in writing between the first claimant and the second defendant, made on or about the 5th day of September 2019. And of course, there was a prayer for costs. Now, your honors, on the 16th of February 2023, the learned trial judge in the High Court made an order. That order was perfected on the 2nd of March 2023, and it appears at pages 125 to 127 of the record. That order struck out the respondent's defense to the claim and entered judgment for the appellants for damages to be assessed. There was a hearing some months after on the issue of the assessment of damages. At that hearing, evidence as to quantum was led and experts were called by both sides, so that the claimants who'd had the judgment entered for them after the defense was struck out, they brought their expert and the government brought its own experts. Now, after that hearing, on the 2nd of January thereafter, the learned trial judge gave judgment for the claimants, in which she ordered damages to be paid to them by the defendants in the sum of $2,085,068.68, I believe. That order is at tab 9 of the record, page 77. Dissatisfied with that quantum, the claimants, the appellants here, appealed. And that, you will see that at tab 7, pages 62 to 67 of the record. The respondents cross-appealed by way of a notice of intention to vary, and that's dated 20th March 2024, pages 652 to 654 in the supplemental record of appeal. Now, Your Honors, I say straight away that in our respectful submission, that notice to vary, which was in effect a cross-appeal put on foot by the claimant's appeal against the quantum of the assessment. That notice of intention to vary, cross-appeal, in short, challenged the award of the $2 million and odd made by the trial judge on several grounds. One of those was that the contract made between the claimants and the defendants, the appellants and the respondents, was a nullity, and that the court at first instance was therefore wrong to have entered judgment and was wrong to have made the liability order. The judgment was entered after the claimants made an application to strike the defense on the basis that it was wholly defective. It did not disclose any proper case. And what is an important, slightly peculiar feature of all this is that the respondents, the defendants at first instance, agreed with the application to strike. The way the order, the judge's strikeout order, framed it is that upon hearing Mr. Lindo, who was appearing then for the claimants, and there being no objection from Ms. Matut, who was appearing for the defendants, the court would proceed to make the order and to enter judgment. In other words, the strikeout application succeeded. Now, at the hearing of the Court of Appeal, the court considered both the appeal of the appellants, the claimants, against quantum, as well as the notice of intention to vary, the cross appeal. Mr. Lindo, who was appearing for the appellants at the Court of Appeal, objected to this on the basis that what the cross appeal was doing, while it was nominally a cross appeal as a consequence of the claimant's appeal saying that the quantum was too low, that basically framing it in that way constituted a sort of bait and switch, because ultimately, as it was ordered, and even in terms of the way the grounds in support of the notice of intention to vary were the way in which they were framed, that cross appeal really was a challenge to the liability order made by the judge when she struck out the defense with the agreement of the defendants and entered judgment for the claimants with damages to be assessed.
Assuming you're right, Mr. Barrow, were the respondents not entitled to seek a variation of the judgment?
The liability judgment.
The judgment by the, yes, the trial judge.
Yes, but
Under section, is it 5 of the Senior Courts Act? And of course, the procedure for filing the notice to vary, those conditions are specified in section 7. But certainly under section 5, the respondent, it seems to me, can contend that the decision of the court below should be varied.
yes, we have no
So
difficulty with
is
that.
is that what the respondents were attempting to do in their notice of intention?
With respect, Mr. President, they can contend that the decision of the trial judge with respect to the damages order or assessment of quantum can be varied. They cannot, in our respectful view, use the fact that notionally, they are cross-appealing against quantum to challenge the earlier finding as to liability. And that really is at the heart of our appeal.
This is what is bothering me, because my reading of section 5 of the Senior Courts Act does not restrict them in the way that you are contending. I would like for you to persuade me otherwise, but section 5 seems to allow them to contend that the decision of the court below should be varied, and there is a procedure by which they can advance that contention. But surely, is there anything in section 5 which says that they can only apply for variation of the damages order?
Well, I don't know if it's spelled out in quite that way, but the notice to vary is a cross appeal against the damages order. That's put on foot, that notice of intention to vary, by the fact of the appeal of the claimants, of the appellants, regarding the damages order, regarding the quantum, which the claimant said, the appellant said, was too low. I don't know how you get from there to challenging the liability order, which was by way of the judgment entered after the strikeout application succeeded months and months and months before. We contend that.
Mr. Barrow, may I just on that point ask you about something? So I think the president has referred you to the rules. If we look at the substantive act, section 124 in relation to civil proceedings of the Senior Courts Act, the power of the court, that's of the Court of Appeal, generally, section 124. Do you have it? Can you turn it up, or is that inconvenient to you? If not, I can share it. If you, yeah. Do you want me to share it, or
please, Your Honor. 124.
Yeah.
Yes.
You have it?
I have it. Yes.
You have it. Okay. All right, but I wouldn't bother to share it. Mr. Courtney, you have 124.
Yes, Your Honor.
All right. Okay. Good. So the power of the court, generally, the court may affirm, modify, amend, or reverse, either in whole or in part, the decision made by the inferior court with reference to the cause, or may render any decision which an inferior court ought to have been made. And then that's A 24(1)(c. Make any other order for disposal of the cause which justice requires. So this is the kind of interest of justice provision that applies in all Supreme Court of Judicature acts.
Your Honor, I'm very sorry to interrupt. Just
Sure.
to provide some assistance, I think the applicable section is 205.
205,
This
right?
is-
Okay.
This is from inferior courts to the High Court. The Court of
205 is the
High-
equivalent, yeah. Yeah,
Yes.
you're right, you're
Okay.
right. It's long and I'm going through and I got stuck at the wrong one, thanks. Yeah, correct. It's 205, yeah. So the wording is, let me just scroll down to it. Thank you, Mr. Courtney. I actually made a note and in my research went to the wrong note. But so in the Supreme Court of Judicature Act, 205, yeah. So 205, have you been able to turn that up, Mr. Barrow?
Yes.
On hearing an appeal, so it's the language is slightly different, but same purport. As I say, when this is across all Anglo-Caribbean jurisdictions in what is called in the old days the Supreme Court of Judicature Acts. On hearing an appeal, the court shall have power to confirm, vary, amend, or set aside the order or make any such order as the High Court or a judge thereof might have made, or make any order which ought to have been made, and to make any such first order as the case may require. Draw inferences of fact, etc., etc., etc. So the point is, this is a section that, in my reading, goes to what we often a little bit loosely speak about. The language is so in this very act in relation to criminal proceedings, interests of justice. My question, therefore, is a question of jurisdiction, because I think that's where we are, right? It's a question of jurisdiction. Does this court have the jurisdiction under 205 to revisit the orders in relation to the sort of cause of action? It may
Liability.
Liability, yeah, everything. In
Yes,
other words,
yes,
everything.
yes. In my respectful submission, no. Absolutely
okay.
no.
All right. So 205 does not give that jurisdiction or power. Yeah.
No. 205
No.
is talking about what flows from the appeal of the order, the particular order that's appealed against. And the order that's appealed against here is the damages order, not the liability
I
order.
understand that, but Mr. Barrow, may I ask you something? This is, as it were, a split trial. That is to say, the cause of action is for liability, and if liability is found, for an assessment of damages.
Yes.
There can be no assessment of damages without a finding of liability. A split trial, as I understand it, this was a split trial. A split trial does not in some way hive off discreetly or otherwise the root, which is liability. So whether it came by default judgment or summary judgment or by consent or whatever it is, here we have a situation where practically you had a cause of action for liability with subsidiary relief for an assessment of damages for breach of contract or otherwise. A default judgment was taken up, and this case
It's not
went.
a default judgment, Your Honor.
It was
with
not?
respect. It's not a default judgment.
What was it?
There's a difference between a default judgment, respectfully, which is entered in default of a defense having been filed or an appearance having been entered. There is a distinction between that.
You're right. In this case, the defense was struck out and
Yes.
the judgment entered. All right. The structure I'm on, so that as a result of a judgment on liability, the matter went to an assessment of damages.
Yes.
What I am struggling with, to be very honest with you about, is the clean separation between the two. I accept that your appeal was an appeal on an assessment. You were not happy with the $2 million order. You thought you should get more. You came to the Court of Appeal on that. I understand that. But as a matter of what is before the court, how do you delink the two? That's what I am not understanding conceptually.
Well, because, Your Honor, the learning in my respectful submission is quite clear. The entry of judgment that resulted in the liability order meant that that liability order was a final judgment. And it could have been appealed, but it would have had to have been appealed in the normal course, hewing to the timelines that are set out in our rules. So many days after.
No, right. Okay, I understand that. I understand that the procedural things. Let's look at 205.2.
If
The
you
powers
want
of
to
the
turn
court,
it up for me, yes.
Yeah, 205.2. That's same 205. You have that, do you?
Well, Ms. Barrow is getting it for me.
All right, okay. I'll give you a moment to get it.
Yes.
So in let me know when you have it.
Yes, I do have it.
Thank you. So the powers of the court under this section, and this is civil appeals, may be exercised notwithstanding that no notice of appeal or respondent's notice has been given in respect of any particular part of the decision of a high court or a judge from whose order the appeal is brought, or by any particular party, or that any ground for allowing the appeal or for affirming or varying the decision is not specified in such notice. And the court may make any order on such terms as it thinks just principle to ensure the determination on the merits of the real question in controversy between the party. Again, I understand the procedural arguments you've raised, Mr. Barrow. I'm very clear on those. I am really just trying to understand conceptually from a jurisdictional point of view. Is there a jurisdictional bar to this court, but to the Court of Appeal, exercising the power it has to review the primary decision?
I think there is.
All right, okay.
Your Honor, if I could turn to our skeleton arguments, there is a case that is Jogi, if I'm pronouncing it correctly, against Sealy, Trinidad and Tobago, 2022 UKPC 32 at 65. It is at tab 5 of our written submissions. And there at paragraph, if you will allow me to find the case and tell you what it says at paragraph 39, I believe it is. Just give me a minute. Is it 39? Page 13. I'm sorry, paragraph 65. It's page 39, but paragraph 65. If your honors will allow me, in my view, Mohan Jogi's decision not to appeal against the order made on 27th February 2012, while continuing to trial, cannot be said to amount to an abuse of process, and there is no issue estoppel. The important point is that Mohan Jogi precisely did not accept that that order validated the proceedings because in paragraph 14C of the defense, dated 4th April 2012, and which followed the grant of that order, and the consequent 6th March 2012 amendment of the statement of claim, the defendant averred that, and it's quoted, the claimant has no locus to act for the estate of Cynthia Abbott, end of quotation. The consistent position taken by Mohan Jogi in the trial and in the appeals to the Court of Appeal and to this board has been that the proceedings are a nullity because they were started when Angela Seeley had not been appointed an administrator, and that the order of 27th February 2012 did not operate to validate them. It is also relevant to note that under Section 39(3), and this is what's important, of the Supreme Court of Judicature Act, Chapter 401, and this is a quotation, "The powers of the Court of Appeal in respect of an appeal shall not be restricted by reason of any interlocutory order from which there has been no appeal." We don't have that here. And so my learned friend, Mr. Courtney, is contending that the liability order is an interlocutory order. I will get to that later. We say it's a final order, but assuming for a moment that it is an interlocutory order without observing the requirements of our Senior Courts Act and the Court of Appeal rules for leave, extension of time, to appeal an interlocutory order out of time, as it were. In my respectful submission, the Court of Appeal had no jurisdiction to hear.
So, Mr. Barrow, does 2023 address that? That is the enlargement of time in the interest of justice.
But an application has to be made.
No, or fair, but or before, so that I understand. I'm very clear on the procedure. I understand. I'm just trying to work out in my head conceptually a more fundamental question. I understand that okay, an application has to be made. You say it is final because it finally decided liability, not interlocutory. I get all of that. That's you know, I whatever. I'm just really trying to work out whether or not, because I think your core argument is we can't even get to this. I think that's how I understand it. Your core argument is, look, this court does not even have the jurisdiction to entertain this.
That is absolutely correct. This court, the Court of Appeal, had no jurisdiction to entertain it absent an application for leave to appeal, an application for extension of time. We do not have anything equivalent to what is set out in Section 39(3) of the Trinidad and Tobago Supreme Court of Judicature Act. The powers of the Court of Appeal shall not be restricted by reason of any interlocutory order from which there has been no appeal. The converse to that is an interlocutory order otherwise from which there has been no appeal will restrict the jurisdiction of the Court of Appeal. And that is our argument. It's not that it is absolutely impossible for the Court of Appeal to have been seized, to have become seized of jurisdiction, but steps would have had to have been taken.
My own preference is to frame it a little bit differently, but this is conceptual. The court has jurisdiction, but ought not to exercise it because there are procedural gaps. I don't subscribe to a view that you lack jurisdiction because of a deficit of procedural rules. I prefer to say you have jurisdiction because the jurisdiction is given to you, but in a certain circumstance, maybe you should not exercise it because leave was not granted or whatever it is. I don't know that they proceed, but anyway, that's an academic thing. But I get what you're saying, so thanks a lot. Yeah.
No. I take your Honor's point and the fact that you have framed it in the way you did, which is much more felicitous and which accords with what we all know to be ultimately the sort of almost all-encompassing jurisdiction of the Court of Appeal. The way you did it frightened me because it made me think for a moment that perhaps in a previous life you were a politician, God forbid, or a diplomat. But let me leave that alone, Your Honor. So if we can.
Maybe you're being prophetic. I still have a life to live, you know, Mr. Barrow. Who knows what the future holds?
If I may come in, colleagues, Mr. Barrow, let me understand and try to understand your case. Is it possible that you are saying that, I'm looking at it now from the perspective of the notice to vary.
Yes.
Is it possible that what you're saying is that the judgment at first instance is something in the nature of a consent judgment?
Yes, it,
Does
yes, yes, it, yes.
So
it
that's
was, yes.
effectively what you're saying.
Yes. And that,
And then is
sorry,
it
I'm sorry.
your argument then is that if that is the case, one cannot apply to vary judgment to which one had already consented in relation to liability. Is that your argument?
No, no. You can appeal that judgment.
I mean, I'm
You
talking
can-
about, I'm limited now to, I'm taking in stages,
Yes, yes, yes.
the notice to vary.
Yes, there could have been, Your Honor, an application to set aside that judgment that was entered when the defense was struck out by consent, if you will. There's always, that is always open. My learned friend talks a great deal about avoiding a miscarriage of justice. There are ways to do that. We concede that straight away. But the route to getting there is just not by way of a notice of intention to vary that is challenging the liability order, which was made months before the damages order, and which liability order, in the circumstances not being a default order, but an order akin to a summary judgment order, but to which they consented, but made under Part 56 of our CPR, which provides for the striking out of a defense where the defense appears to be wholly defective, where the defense discloses no possibility of any kind of substance. And
so is it the case that the party who applied to vary in this case was the same party who consented?
Absolutely.
And is it your case that one may not readily do that? That if you've consented, you cannot turn around to apply to vary?
Not without filing, not without either appealing.
Correct.
Perhaps you have second thoughts. You with the sort of
you realize you might have made a mistake or something.
Esprit de l'escalier. You realize belatedly that, oh, I should have said so and so.
Yes.
So there's nothing to stop. There was nothing to stop the defendants from applying to set aside that, if we will, consent order. And they could have done so before the very judge that made the order or before another judge. Or they could have, within the 21 days or the time specified, appealed the order, notwithstanding that they consented. The better course would have been to try to set it aside. But not having done either of that, they can't come and use their cross appeal against the quantum, which was in fact done after, with their participation. They put up expert evidence and all that. They can't come and, by way of the cross appeal against that assessment order, go back and challenge the liability order.
But I'm trying to understand now the limits of your argument or the reach of it. If you say that a party who obtained, as it were, a consent order or judgment can come later and apply to have it set aside, why can't they then apply to vary it?
Well, Your Honor, two things. As long as that judgment entered by way of the strikeout application succeeding stands, it is a final judgment.
Which you say they can also apply to set aside, though
Yes.
it is a final judgment.
Yes, they can apply to set aside a final judgment on the
But why-
basis of
What
miscarriage of justice. But there are time as a
Time
matter of
bars.
yes, Your Honor.
But is it possible that they can also apply to vary that final judgment?
No, Your Honor.
Okay.
Because, and especially not when the application to vary that liability order is not put forward as such, is not put forward per se. Indeed, you will see when we come to look more closely at the submissions and at the record that Mr. Courtney, my learned friend, kept insisting that we're not challenging the liability order. We're only challenging the damages order. But as a matter of logic, because in order to challenge the damages order, we must refer back to the liability order. That comes into play. But my learned friend insisted the burden of the notice of intention to vary is not that notice seeks to impugn the liability order. Of course, when the Court of Appeal gave its decision, it made it absolutely clear that that was nonsense. I'm sorry, let me not use that term. That simply could not fly. That in fact, the notice of intention to vary was centrally as a core position, impugning, seeking to challenge the liability finding. And that is what we say cannot be done.
Yeah, Mr. Courtney, I'm Mr. Barrow, excuse me. There's an aspect of this case that interests me, and I think Justice Jamada took you there to 205, is it? Sub 2, which speaks about what the court thinks just. I saw that Justice of Appeal Balkan, as he then was, began his judgment considering what was substantively just. What is justice? And so I wanted to hear you on this aspect of it. Is it that you say that what the Court of Appeal did was not, in your view, just, or an exercise of substantive justice, so procedural fairness? Do you go that far in your submissions to us?
Your honor is placing me on the horns of a dilemma. I will have to be very careful in answering the court. What I'm saying is, Madam Justice, the Court of Appeal ultimately does have the power, but it is not a power that's unrestricted, that's unfettered procedurally. Look, I come back to the difference between our Senior Courts Act and the Supreme Court of Judicature Act of Trinidad, which says the powers of the Court of Appeal in respect of an appeal shall not be restricted by reason of any interlocutory order from which there's been no appeal. The converse to that has to be that absent this provision, the powers of the Court of Appeal would be restricted.
But Mr. Barrow, that is a non sequitur, with respect. That is a non sequitur. Because the Trinidad and Tobago Supreme Court of Judicature Act and the Joey case is well known to us, practical practice in those courts, because the Supreme Court of Judicature Act makes it clear, I think it would be a read-in to 205 of your act to say, read it in the way you have suggested. That is to say, the absence of that section has implications for the interlocutory order. I would suggest that the way to read 205 is to read it for what it says and inquire what are the powers it gives to the court. To my mind, the non-reference to interlocutory orders is not an indication that that is a limitation. To my mind, the non-reference to interlocutory orders simply invites us to read 205 to figure out what is the power. And as Justice Rajnath Lee has come back to 205 to the last two lines say to, and I quote, ensure the determination on the merits of the real question and controversy between the parties. So if one has to look at the ambit of power and jurisdiction, it would appear to me that that describes it. The question is, in this case, and I think it's a legitimate question, and Mr. Courtney will come to, I don't know, thread this needle between what he's trying to impugn or not. We'll get to him, I guess, in due course. But I think the question is whether or not the primary order can be varied. And if it is that a party makes a concession, as you have described, a default application to strike a defense, and they say, okay, they agree and judgment is taken up. If they make that, and they recognize subsequently, I'm creating a hypothetical, that that was a wrong concession in law. But it's not a question of an exercise of a discretion within a range that is legally permissible. That is wrong in law. It's fundamentally wrong in law. Are they entitled to come to another court and say, look, we need to vary that because this is a fundamental error of law? Or are they not? Can they not resile even from that consent?
No, they can come, Your Honor. But not everyone that cries, Lord, Lord, shall enter the kingdom of heaven. There's a route by which they must come. And as I said to Mr. Justice Ibo Osuji, they can come if first they apply to the court at first instance for leave to set aside that consent order. They can come if they apply not having appealed the consent order for an extension of time within which to appeal. They can come if there's an argument over whether that liability order is final or interlocutory. In all respectful submission, it is final. They can come if they ask the Court of Appeal for some special permission, given that they would not have complied with the rules governing appeals from interlocutory order. That is on the assumption that it is
if
an
it
interlocutory
is
order.
that all of those
You can't just comment.
If it is that all of those shortcomings can be appropriately dealt with what can be dealt with appropriately with orders for costs, etc., is that a consideration in terms of fairness?
That may well be a consideration if the application is properly made, or put it another way, if a proper application is made. You can't just come to the Court of Appeal and say, I am only appealing against the damages order, but as I flesh out that appeal, this court will see that in effect I am impugning the liability order without having asked for any permission to do so, given that either that liability order, one, was a final order from which there's no appeal out of time, or if it was, as my learned friend says, an interlocutory order, then it must have been appealed within a specified time. Of course, ultimately, the Court of Appeal, any court in terms of the breadth of its remit to do justice, can find a way. But it can't be, the court is a creature of statute. It can't be that you can simply drive a coach and four through the rules that provide for leave to appeal interlocutory orders for timelines, for time frames. You can't just pitch up in front of the court saying that you're cross appealing your notice of intention to vary is with respect to the damages order, and then do as I said, what amounts to a bait and switch, you turn right around and you go full tilt at the liability order. And when we come to look at the judgment, your honors will see that Mr. Justice Balkan made it plain that notwithstanding what my learned friend said about the notice of intention to vary not having as its primary purpose or as its purpose at all a challenge to the liability order, that was what it was. Mr. Justice Balkan said that and treated with it on that basis. I can take the court to
No,
those
I think
passages in
I
the
think we I
decision
think
now.
we follow you. I think we follow you on that, please, Mr. Barrow. And you know, we take the point that the respondents ought to have been clear, perhaps, in what they were seeking. I go back to Rule 5 because Rule 5 does allow them to apply to vary the decision, not just the order, but the decision. And in response to my brother earlier, you said that 205 wasn't really relevant because, as I understood you, 205 comes in relation to the kinds of remedies that you can give when you have properly sought the approach of the court to vary. So that if the notice had come within the terms of Rule 5, I take it that your view then would have been that 205 could have been applicable and relevant.
Your Honor, I don't want to sound like a stock record, but in my view, there is no way that the court could have entertained the challenge to the liability order except that order had not remained a
Yes.
final order.
Yes, and
Or-
I'm sorry if I were to provoke you to be a broken record. I'd hate to do that, Mr. Barrow. So I follow that you're going to repeat what you said earlier. Just one other question. In terms of the economy of judicial resources, would it not make sense to have this challenge, cross appeal, notice to vary, whatever you wish to call it, in a sense, consolidated with your appeal? So instead of having separate rights arbitrary, one party than the other, and having the court navigating between that, to bring everything together. So you have your appeal and you have, as you said, the cross appeal by the respondent. Does that make sense from the point of view of the saving of judicial resources?
But, Mr. President, with respect, appeal and cross appeal regarding the damages order, there can't be an appeal and cross appeal regarding the damages order and regarding the liability order, because I say again with the greatest respect, my learned friend can't get at the liability order except certain preconditions are satisfied, one of which is that order has been set aside or that order was appealed from, or my learned friend asks for leave to appeal the order if it is conceded that it was an interlocutory order, which we don't concede, out of time, with permission for the extension and giving the other side a chance to weigh in on that. So I think to be quite clear, Mr. President, we're not saying that there is no jurisdiction vested in the Court of Appeal, period. No, we're saying that how that jurisdiction can be provoked is altogether a different matter, and it is the core, it is the central matter. and it can't be provoked simply by way of a cross appeal or notice of intention to vary regarding the damages order, which turns out to be
More than that.
to be a many layered cloak that conceals within its folds an attack on the liability order.
So you're saying, Senior, that these have to be done in stages. They can't be done all together. You have to challenge the liability first, and then you could later on perhaps challenge the damages order. Right?
Indeed, Mr. President. And something that happened below is perhaps a pointer in that direction. When this appeal first came up for hearing, as I understand it from Mr. Lindell, 2 days or so before he submitted a late authority, or perhaps the morning of. That authority, Mr. Lindell, please help me. That authority was the welding, the what's it called? The
Caribbean welding.
Caribbean welding. As a result, the Court of Appeal said, well, no, this is coming very late. Mr. Courtney will need time to respond to this. We'll give him that time. And so they adjourned the Court of Appeal, the case from that session of the Court of Appeal to the next session, which was from October to March. So that's a pointer. Perhaps the Court of Appeal in this case might have said, listen, we ultimately have the jurisdiction, but not as things now stand. You can perhaps go and get this question of the impediment constituted by the liability order out of the way by applying below to set it aside on the basis that that order constituted a miscarriage of justice. You can apply for time or you can apply for leave to appeal it out of time and for an extension of time, but the other side will need to respond. So we will leave that for the next session.
Yes.
Mr.
Perhaps that
Barrow.
might have been a solution.
Yes, Mr. Barrow, I know your time is coming to a close, so I just wanted to return to section 205 to ask you a question. There's been a lot of exchange on whether the Court of Appeal had jurisdiction to entertain the notice of intention to vary. But there was no question, of course, to the Court of Appeal's jurisdiction to consider the notice of appeal that had been filed. I don't think that's an issue in any way. And so my question is, upon hearing that appeal to the damages order, why would the Court of Appeal not have been able? Remember, I'm parking the notice of intention to vary for the moment.
Yes.
On hearing the actual appeal that was filed, why would the Court of Appeal not have had the power captured in the last part of section 205(2)? In other words, it's hearing this appeal against the award of damages. What would have precluded the Court of Appeal from making the order that it considered just to ensure the determination of the merits of the real question in controversy between the parties? So let's assume no notice of intention to vary had been filed, and the Court of Appeal is considering the appeal against the damages order. What would have precluded the court from assessing what's the real question in controversy between the parties, given the arguments made, and making the order that it considered just in those circumstances? Thank you.
A number of things, Madam Justice. Number one, that was not the list. That was not the issue between the parties on the appeal. And number two, as if you look at paragraph 13 of our written submissions, as the case of Vehicles and Supplies Limited and another against Financial Institution Services made clear, a summary judgment in proceedings in which a defendant appears and offers a defense, but the defense is held to be wholly defective, is a final judgment on the merits and gives rise to estoppel per rem judicatum. When you look at our second set of written submissions in reply to the respondent submissions, we cite a number of cases, including the Jamaican case of Strachan, I'm not sure how you pronounce it.
Strawn, yes.
Stracha and
Yes, Strawn.
yes, and before that the Lunum case, in which Lord Justice Peter Gibson said, "It is not in dispute that when judgment in default is entered for damages to be assessed, the question of liability is thereby determined and cannot be challenged while the unappealed judgment still stands." So my answer to you, Madam Justice, is that it would not have been possible to do it in the circumstances. They would have had to, it would have required a separate consideration by way of a separate route, by way of a separate approach to court. It could not be done as a kind of add-on to what was before the court, the list that was before the court, which was exclusively and only solely the question of the damages order.
Okay, thank you.
You know, Mr. Barrow, I think that you're saying, and correct me if I'm wrong, that we cannot get to the liability question because of the procedural requirements that were not met by the respondents.
Yes, no, at this point, it's not that there's not a route by which that may be done, but it can't be done in the context of it, within this particular paradigm and context.
Yes, I understand. If we were not to agree with you, if we were not with you on that point, and if we got to the question of liability, I'm intrigued by your understanding analysis of the Andre Vigo against AG case. As you know, that featured extensively in the Court of Appeal decision by Balkan JA, as he then was. Do you think that your case at that stage, if we got there, and I know you say we shouldn't get there, but if we got there, do you think that your case would turn upon the correctness of that decision? And if it did, would you want to hazard a view as to why we should agree that that was the right decision?
Your last, could you repeat the last portion of your sentence?
If we were to get to the issue of liability and we were to look at the Vega case, which I suspect you may have to rely on if we got there, I'm just trying to offer you the opportunity to convince us as to why the Vega case, in your view, was correctly decided, assuming that is your view.
Well, first of all, I don't think we should get there because, quite frankly, Your Honor, that the reason why the respondents conceded the strikeout application was because, and I think Mr. Courtney was quite forthcoming where that was concerned, in explaining to the Court of Appeal that issue, was because the government thought that the decision of Justice of Appeal Minot Phillips bound the first instance court in this matter.
But it will not be binding on us, clearly.
I'm sorry?
That decision would not be
not be binding on you. No,
clearly.
no,
Yes.
no.
So I'm inviting you to give us some comfort in reaffirming the decision in that case.
Well, Your Honor, I find myself in a little bit of a difficulty because it's not something that I have thought about, because I didn't see how we could get to it. Just off the top, I will be candid enough to confess that at first glance, the notion that there can be two ministers' fiat grants to different persons over the same portion of land is a bit, seemingly a bit of a stretch, but I
Sorry,
don't.
Senior, did you say at first glance or is it at third glance?
Well, I haven't given it a third glance. I
Yeah,
said
but-
I thought I didn't need to, because clearly it at that time, without the intervention of a second court of appeal or of the CCJ, the learned trial judge felt that it bound her, and so did the respondents. And it did. So
certainly at the High Court, not to interrupt you, Counsel, but at the High Court level, it would be
indeed,
binding, and at the Court of Appeal level as well, subject to the
Indeed.
exceptions in the Young against Bristol.
so I
opinions.
didn't see the need to go beyond that, quite frankly.
Yes, but because you're before us, I thought you may have given it some thought. But be that as it may, did you wish to urge anything further on us?
Well, I would have asked Ms. Barrow to address you on the question of the damages, the quantum. But
Yes.
this is such a threshold issue. This is so determinative that perhaps the better course is to say that if your decision on this issue is such that you do need to go on to look at our appeal against the quantum, we could simply rely on our written submissions.
Well, subject to any objection by my colleagues, we're very happy to hear Ms. Barrow if she wishes to be heard.
Ms. Barrow?
I rather fear that the tone of this appeal has gone contrary to what I anticipated, that we are at the preliminary issue, which I think remains clear based on the procedure and rules that exist now, as we've known and applied them, that the year that has passed, for people to be able to come to court after a year to challenge a decision that has gone before and has been relied upon by the parties, it's intimidating.
But it shouldn't
Well,
read too much into
Ms. Barrow,
yes,
on that,
brother, please go ahead.
yes, thank you very much. Ms. Barrow, on that point, you said you feared that you came to argue procedure and the case seems to be running away from you. It seems to be what you're saying. I retorted to on that and what Mr. Barrow said when he said at first glance and looking to see two fiats granted in the same, in relation to the same parcel of land. He said it seemed a bit of a stretch. I think we can say appears a little odd. We can put it that way. Now, on that basis, we are familiar with the adage that the rules of court, Ms. Barrow, are handmaidens of justice and not the master or the mistress of it. And the case for the respondents is really that. How do you get around the difficulty that two fiats granted in relation to the same parcel of land? Is that the question of justice in this case? How do we get around that with arguments about the procedure that you came to argue? I'd like you to help me, please.
Yes,
Are you still without?
she's
It
frozen.
looks like you're.
Frozen.
Yeah, I can see she's because it's popped up on the other side.
Ah, please.
But the
you're
microphone is muted.
Could you unmute,
It's
please?
muted.
Thank you.
Oh, thank you. The issue is, as a purchase of land from government, do we go and investigate every title represented to you from the government as being good, which is what a minister's fiat grant is. It is a title being represented to a purchaser as being good. It is then not, it is not the duty of purchasers, of persons dealing with the registry, to go behind the registry's title, the duty of the registrar. And we have had cases recently in our first instance court, which makes clear that the registrar has a higher duty than originally contemplated in terms of making representations to people. So as a
How far do we go with that, Ms. Barrow? What about, okay, here we have a scenario where two fiat grants are in relation to the same property, and you say maybe we shouldn't go behind, or what if about 3, 4, 5 fiats in relation to the same grant? Are we going to say, sorry, we can't go behind that because we see grants?
no, Judge, that is by no means what I'm suggesting. I'm saying, what then is the recourse? And the recourse, as it relates to reliance on representations made by the government, becomes an issue, which was not what was being discussed here. The liability order, to go behind that liability order, requires us to look at the title, the nature of title, and whose error it is to issue multiple titles, who then becomes liable to the purchasers who have gotten multiple titles from the government. And that is what has happened. There have been representations made.
So, Ms. Barrow, isn't that the root of the problem? The root of the problem is this question of title. That is to say, if before the trial judge, this issue was litigated, then some of these questions would have been answered. What has
Absolutely.
happened is, no, I agree. But the question...
I agree with all that the court is saying, that these are intriguing and provoking questions, but they weren't provoked. The judge nor the parties were...
Is there a compensation fund for your system in Belize?
No, Judge. And what our clients were ordered to do is get back their money that they paid, and all the years that have gone, the money is paid on litigation. All of those things were not contemplated one bit. So those are issues that ought to be ventilated properly, but this is not the way you go about doing it. It is not the way the government has the right to question and do this again, because it's not one time they've done it, Judge. It's not the first nor the last. The occasion to litigate this will come up again. It has come up since. And the issuing of multiple titles, unless the registrar is made, or the registry is made to be, I don't know, almost foolproof, it will happen again. So there's a time and a way to get to it. And it is not by going back a year. It is by waiting for the next occasion if you think that there's something wrong, and not stopping with the Court of Appeals decision and appealing to the CCJ. Because if Vega is wrong, if the government apprehends that Vega is wrong, there's a way to get to you. This is not how you do it.
You know, Section 17, I believe, is it the National Lands Act, is the section which allows the minister to, by fiat, make grants of lands. Okay. So that is the ministerial power. But earlier, I think it's Section 16, it says that the registrar shall keep certain books to be termed the National Lands Books in various forms, etc. So correct me if I'm wrong, but is it not in these books that there will be the entry of the grants?
That is the issue, Judge. Sorry, President. That is the issue. It is that these books are not being properly kept, and we are getting more decisions coming from our first instance, impressing upon the registrar how serious and grave these duties are, because people rely on them and they aren't accurate, and then all of this flows. But as a lay person, I'm entitled to go to that book, prove that I have done what I needed to do, and the book doesn't reveal it.
I don't want you to give too much evidence from where you sit, but can you tell me whether there was an inspection of the books, the National Lands Books in this case?
I am not certain. I remember there was recital in the claim form as to how it became apparent to the claimant, the fact of the existence of the other title. And I think Mr.
Right.
Lindo can better help in that regard. It is in the statement
that,
of
that
claim.
would be interesting. And of course, I'm sensitive to an objection that Mr. Courtney might make. But I'm curious because you're saying that basically once the minister issues the Fiat, that's it. And you should be able to rely on the ministerial grant. But if it's a simple matter of simply checking the National Lands Book, isn't that something that would be reasonable for any purchaser or grantee to do to ensure the validity of the grant? What do you think?
If I may just direct the court to pages 84 through to 85 of the record, and it shows what all was done. The claimant, when they discovered a year later the existence of this other title, they informed the government, and the government told them to submit a grant rectification instrument. That's paragraph 9 of the statement of claim appearing on page 84.
So, Ms. Barrow, the discovery was made 1 year after the contract.
Correct.
So what I'm asking you is it unreasonable for there to have been the search of the National Lands Book at the time or before the contract was concluded?
How they said it, they discovered it was from a third party. They did not discover from the book. Paragraph 8 said that they discovered that the second defendant had previously disposed, for a constated, and they don't say how they discovered it. But it says that it was discovered. I don't know how the discovery came to be. But what I see happened here is that there was permission given to survey, and usually they don't give you permission to survey land that belongs to other people. That is what I see.
But would you, without taking this too much further, would you agree with me that it would not be unreasonable to expect the grantee to at the very least have a look at the National Lands Book to see whether the grant to him was already granted to somebody else?
Absolutely. And the government issuing the title. Both parties are charged with it. If I am applying for it, I would have checked. And if you are giving it to me, you ought to have checked too.
Yes, but in terms of the definition of a bona fide purchase of a value without notice, would you say that the grantee has that obligation before such a person would qualify as a bona fide purchase of value without notice?
I believe so, Judge. Without
Okay.
Without knowing more, that's what I would say, Lord President, that you have a duty to check constructive notice, and that is the issue, that the deficiency in the title books, the deficiency in the record is what puts us in this position. I am assuming, without even being instructed as to otherwise, that they had to have checked before they made the application.
Well, no, let's not make that assumption because we don't know.
It is the normal practice that you check for the history of titles before you apply for them, is my understanding.
Very well.
Yeah. Miss Barrow, can I ask something coming out of that discussion? You seem to be suggesting, or you are, that this is not a one and done case, if I may use that term, that there are other people who are being given lands by way of the minister's fiat grant, and someone else already owns that land. I was curious that there was that application for rectification. It appears that a number was rectified and the parcel of land remained the same. How does that happen from your knowledge of the practice? I want to say that. And again,
I don't want to be cheeky, but
hold on, if Mr. Courtney feels that that is an unfair question or he wishes to speak to it, I'd be happy to hear.
My senior used to be a minister of natural resources. Maybe he can answer. I don't know. I don't know how it happens. I really don't.
That sounds like a poison chalice.
But Ms. Barrow, it's a question that goes to the merit, because
So,
if it
sorry,
is that
my brother, Justice Zabaneh, I don't know whether Mr. Barrow wanted to respond. I'm not sure he does, but just in case.
What was that?
So the rectification being issued with the same number, the same,
Same
a
parcel.
different number for the same parcel.
I
Given
can't.
your extensive experience as a minister
Well,
of is it
well,
natural resources?
well, Mr. President, I was Minister of Lands for a short period in name only. I made it absolutely clear that the Deputy Minister, who is currently the CARICOM Secretary General, would have complete control over the ministry. I wanted nothing to do with the tangled mess that I thought was insoluble. I gave her a basket with which to back water, but I was, I repeat, minister in name only. So I have no familiarity with the practices and processes over there.
Thank you, sir. Thank
Yeah,
you.
thank you,
Judge,
Mr.
this is Jamadar. Yes, sir.
Yeah.
Yes.
No, I just
My
wanted
brother
to
thought I was
ask
gonna ask.
Ms. Barrow, because you see, your clients had knowledge that before 2019 had knowledge that this parcel of land had already been disposed of by ministerial fiat, correct?
Correct.
All right. You were advised to do a rectification, and you got a 2019 rectification, which changed a number, as Justice Rajnath Lee has raised, but in fact maintained the conveyance of the same parcel of land. Well, we can't explain that, but what seems to me to be relevant in this case is that your client, knowing that the parcel of land, and a conveyance of land is not about a number, it's about something that is very concrete, that is to say, land on the ground. Your clients, knowing that this land had already been conveyed, engaged on advice, one assumes a process, gets a rectification and relies on that for the basis of this case for a breach of contract, knowing that the rectification was a paper rectification but did not solve the problem. That
Well-
knowledge must be ascribed, I would think, reasonably, because the description of the land never changed.
But with respect, Your Honor, how do they know that they did not sort out the matter with the other third party? How do they know what was done in relation to the other third party that had it before? If reparations were made to them, there's no way for them to know.
If it had been sorted out, then why would you have had a need to change a number? If it was that the 2005 fiat had been somehow cancelled or rectified or removed from the record, then they would have been reasonably, I'm just speaking reasonably speaking, because we don't know the facts. I think for me, that is a big problem in this case. The big problem in this case is we have not had a proper inquiry into the facts. And we've reached this stage of an assessment of damages, but we really have not had a proper inquiry into all of the things we were asking. But it would seem to me on the face of it that your clients knew that there was, this land had been dealt with. You got a rectification, a change in number, and you went ahead and then sued, and we have reached where we have reached. So I don't know that there are answers, but there are questions in my mind.
And Judge, you know who is the defendant to this matter?
Who is the defendant in this matter?
The party who was issuing the rectifications.
Well,
and the title.
Mr. Courtney has all the explanations, and he will give them to us in due course. I have no doubt about that.
I will cede the floor to him.
All right, good.
Very well. Anything further, Mr. Barrow?
No, Your Honor, I see that the questions and events have overtaken the issue of the appeal against the quantum, and that makes all the sense in the world. Clearly, what we're on has to be determined before there can be, before it can make any sense to go on to deal with what we've said with respect to the methodology and certain omissions, as we describe them, in the court of first instance regarding how the amount, how the quantum was come up with by the judge. But clearly we can rest on our written submissions where that is concerned, because this is really the key. And unless and until this is sorted out, there's no point getting into that other matter.
But Mr. Barrow, I want to ask you a question about that, because for me, this is an important question. The Court of Appeal ordered that your 2016 Fiat grant is null and void, and ordered that you be repaid the $2,000 odd that you paid for that. Would you be of the view that if there is a revisit of the primary order, I call it, the liability order, that what really should happen in this case is that whatever defense has to be raised, which was not a limitation, which is no longer a limitation defense, obviously, right? Remember,
yes.
The defense on the papers in this
initially,
case
yes,
is a limitation defense,
yes,
right?
yes, yes.
Given everything that has happened, would you say that what is fair and just is that the liability order be vacated, let's call it that way, whatever it is, set aside, that the defendant be given an opportunity to file a defense, pleading whatever its current defense is, and that what is fair is that the parties, including your parties, get an opportunity to properly litigate that issue? That is what is fair to you, so that whether the 2008 was cancelled or not, or whatever, how would you respond to that?
Well, Your Honor, I don't know that I would go as far as to say I would consider it fair. I certainly would consider it Solomonic, but fair is a little bit of a stretch for me, simply because, let me just ask Ms.
No,
Barrow
pause.
to turn
You
off her.
misunderstand me. You understand me.
There's a-
Suppose we are, the hypothetical is
feedback.
this.
There's a feedback, Your Honor. Could we
Yeah.
just?
Yeah, I'm not trying to deny you that your argument is that this should not be considered at all. I get that. If we are not with you on that, my
Yes.
question, so that I'm not trying to negate what you have put forward as your primary argument. On the hypothetical that we are not with you on that, my question is, the Court of Appeal chose to set aside the 2016 order, declare it null and void, and order the repayment of the $2,000 to you. My question is, if it is that there is to be a vacating of the primary order on liability, should this matter go back to the pleading stage so that the defendant can properly plead whatever case it wants to plead, to give the claimant a fair opportunity to have a rejoinder, reply, and litigate whatever issues or collateral issues may arise at that primary stage? Because what has happened in this case is we have all proceeded on an assumption of whether you call it default judgment or whatever it is, on assessment. And that primary issue, which the Court of Appeal said, in response to Mr. Courtney, is what is being varied, has never really been litigated. That's what I'm asking you about.
Yes, I understand. It's an eternal truth and verity. If you would forget I think truth and verity mean the same thing, but that's the way the phrase is coined. It's an eternal truth and verity that half a loaf is better than no loaf at all. So from that point of view, what the suggestion that Your Honor makes is one that we would be, if not pleased, certainly prepared to accept.
Okay. Thank you very much. But as I understand it, you're not abandoning your appeal, which is that
No,
the
Your Honor.
damages awarded were not as high as they should be. Very well. Justice and Honorable, is it time for us to take a break, ma'am?
I thought you never asked, President.
So we're about to take a break for about 10 minutes. Before we do, however, I have had the opportunity to look at the practice direction number 5 of 2024. And at first glance, I must say that Mr. Barrow seems to be spot on, and that speaking notes must be emailed to the court no later than 3 days before the scheduled hearing. There are other conditions as well, but that's the one to which he referred, and I think he's right on that. Notwithstanding that, of course, I'm sure he would agree that the court has the discretion to waive that requirement, assuming it was persuaded that it was appropriate so to do. That would require arguments, of course, from Mr. Courtney as to why he did not abide by the practice direction, and rebuttals by your good self, Mr. Barrow, if you chose to rebut. So the question to Mr. Courtney is whether he wishes to go through that process or for us to dispense with the speaking notes. Mr. Courtney, please.
May it please the court. Your Honor, I confess that I was ignorant of that provision in the practice direction, and I apologize to the court and to my learned friend for contravening it. Your Honor, I am quite content to guide myself with the speaking note for myself, and will not insist or ask the court to have regard to it. I will repeat what is in it orally.
Thank you very much, sir.
Obliged.
So with that, we will break. I'm sorry. We will break for 10 minutes and resume. That will be 12:40 Trinidad time. I suspect that is a little early in Belize. 10:40. Thank you very much.
Mr. President, I think you're muted.
My apologies. I was just saying, I think we're now ready to hear from you, sir. Please proceed.
Deeply obliged. May it please the court. Your Honors, the court, the appeal ended where I wish to start.
Mr. Courtney, if it had ended where you want to start, then maybe I can help facilitate that, if you'd be willing. Just help me with the record. Is it correct that a defense was filed in this matter? Was that defense struck out or withdrawn?
Your Honor, the defense was filed. It appears at page 115 etc., and it was struck out. And it is incorrect to say to this court with the consent of.
All right, no, leave the consent for a moment. So it was struck out. So is it correct then that on the record there is no defense in this matter, it having been struck out?
That is correct, Your Honor.
All right. Was any evidence ever taken in this matter as to liability?
Mr. Barrow, your mic is not muted. Sorry. No, Your Honor. On the question of liability, no.
And on the claimant's case or plaintiff's case, claimant's case, the facts, the defense having been struck out, the facts pleaded, is there any joinder of issue with those facts pleaded on the record?
Once the defense was struck out, no, Your Honor, but
therefore, sorry?
Yes, I said once it was struck out, no, but prior to that, yes.
No, of course, we'll be at the stage of it being struck out.
Obliged.
Therefore, under the Belize rules, as I understand it, there being no defense, the pleaded facts, unless there is an express denial or requirement to put to proof, they are admitted. That's a question of law.
They're to be treated by the court as if they are accurate, true and correct.
And therefore no need to prove them, agreed?
Your Honor, I'm not sure I would accept that. If we're talking about the statement of claim, we rely on Locke's location to say the court must still.
I understand. But I'm a question of pleading and admissions. If a case is pleaded and it asserts a positive fact, a defense under the rules must either join the issue or put to proof. You have an option to put to proof. In the absence of those two, there's a rule, I turned it up, I can't remember it now. Under admissions, those facts pleaded of positive material assertions are in law deemed to be admitted.
Yes, Your Honor.
Right, okay. No, were witness statements filed in this matter? Not damages. Were witness statements filed in this matter? No.
No, Your Honor.
So what is troubling me, Mr. Courtney, is this. Let's suppose we get through all the procedural rules, Rule 5, notice to vary, jurisdiction, power of the court. Let's suppose we get through all of that. And we reach the point that, look, the damages and the root cause of the damages, the liability needs to be revisited in the interest of justice. Suppose we reach there. On what evidential basis, this is my question, based on the record, that is the pleadings that have contain admissions in this matter, was the Court of Appeal entitled to say that Grant 157 of 2016 is null and void? That's a declaration, right? That's a declaratory order in rem.
Yes, sir.
On what evidential basis could they do that?
I don't think that conclusion was on an evidentiary basis. It was on a basis of pure law.
And what is the pure law? Was there some pure law indicating that 15216 was materially whatever, fraudulent? I don't know what is the pure position of law that 216 is null and void?
Your Honor, it is the statement of claim which says to the court that a grant was issued
Yes.
I found out that it was issued after I got my grant,
Yes.
and therefore I have a second grant.
Yes.
Section 17 of the National Lands Act, read together with fundamental principles of land law, says you cannot have two titles for one piece of
I
land.
understand that.
And therefore the court held, as I understood the Court of Appeal decision, that the second grant is null and void.
But therein lies the rub. The law says you cannot have two. That's a question of law. On the statement of claim, we have two. Well, we actually have three, but forget that. We have two, right? Fair enough. We can only have one as a question of law. Agreed?
Yes, Your Honor.
Wouldn't the question of which one should prevail be a mixed question of fact and law? How do we move to the decision as to which one prevailed? As Ms. Barrow suggested, suppose you have two on the record, but one had been on the evidence, how to put it, satisfied or whatever. So my theoretical question is, I accept what you say. The law says you can't have two. The pleading says there were three. One has to prevail. Agreed. The choice of which one? What was the basis for saying 2019 must go?
Because, Your Honor, as a matter of pure law,
yes,
as a matter of pure law, both common law and the National Lands Act, it is impossible for the government to grant title to land that it does not own. And on the pleadings, which was the only thing before the court, what the claimants said was that I found that out, I knew it, I told it to the government, and the government gave me a second grant for the same piece of land which it did not own. And I am now coming to ask the court to give me a remedy.
Does the pleading say which it did not own?
Your Honor, can I
I'm
take
asking. I'm not. I don't have it before me. I'm asking you. Did the pleading say that the government said the 2019 thing was a replacement because it was transferring land that it did not own? Did it say
Can
that?
I read? Can I read paragraph 10 of the statement of claim? The second defendant, meaning the Minister of Natural Resources, in an attempt to rectify the defect in title, issued a minister's fiat rectify error number 6 of 2019 to the claimant on the 5th of September 2019. On the event date, the second defendant, the Minister of Natural Resources, reaffirmed the contract by issuing Minister's Fiat Grant number 157 of 2016. And then they exhibit the rectification, and the rectification reads, Your Honor, page 98. Minister's Fiat Grant number 304 of 2008 was erroneously issued to Rudolph Ramirez. So the minister is saying, I gave you a title in error.
That's 2008.
Yes.
But the purport of 2016 is to rectify. The minister is also, so that I'm just trying to get at, is there hidden in this an assumption? But let's leave it. I'm thank you for the gap.
No, Your Honor,
sorry.
I would like to explore it because of what my learned friends have said to this honorable court. It is absolutely necessary for me to say something on this.
Sure.
This court, I am asking to question, why is it that a person who knows that the government does not own land, and the government who knows that it does not own land, would together issue title to that very piece of land? This is not a mistake. There is no ignorance of the prior grant. This is with knowledge of the prior grant. It brings us, Your Honors, to where we are today. Parties before this court saying I paid $2,870.20 for 14.76 acres. And I want the court to cause the government to pay me in excess of $8 million for a piece of land, which I knew the government did not own, which I knew was owned and transferred to someone else already. But I come to court. Why? Because the courts, in my respectful submissions, have been enabling.
All right, so Mr. Courtney, let's pause about what the court is enabling. If you now had to file a defense to that claim, what would your plea be?
Your Honor, I would put virtually the same defense that was filed. The defense was not only limitations. The defense expressly said that government did not have title and government could not grant title.
Exactly.
And therefore, yes,
Exactly. So that's the point. Then you would have joined issue on the fundamental question, which is title. Correct?
yes, Your Honor.
And in that interrogation, everything that you are talking about, no doubt, would have been explored, and whatever would have happened would have happened, and the court would have come to a conclusion. My only little query, is whether the fact is on the state of the record and on a balance of probabilities, given the rules of admissions, etc., the order overreached, and whether the order should have been a remittance to the trial court with permission to file a defense and the matter to be properly interrogated. That's my only query.
Obliged, can I respond? I say this. If this court, and I'm strongly urging this court to make a decision on Andre Vega. My learned friend, Mr. Barrow, shied away from whether or not it is good law. I say unequivocally, without reservation or condition, it is manifestly bad law. Where the Court of Appeal said that the second grant was effective to give title, it is bad law. Section 17 of the National Lands Act has to be interpreted in terms of the definition of grant in the Act, which says, and I quote, Section 2, grant means a land certificate or a conveyance effectual to pass an estate in fee simple to the grantee, subject to the terms and provisions of this Act. It is impossible to pass an estate in fee simple under a second grant by the government. And if this court rules, as I'm inviting the court to do, that a second grant does not pass title, then, Your Honor, if to follow the hypothetical is sent back to the High Court, we will be confronting the mystery that we have identified. And Your Honors,
No, but Mr. Courtney, see, I'm in total agreement with you. Let me ask you another slightly technical question. In terms of the issues that have been raised, was what you just said about the jurisprudence on Vega interrogated in the Court of Appeals decision and resolved decisively, as you suggest?
In my submission, we made submissions on Vega, and my learned friend has alluded to.
No. Did the Court of Appeal decision in this matter, resolve the Vega issue as you have just articulated it,
yes,
decisively as you have suggested?
Yes, Your Honor, it did.
So we have that jurisprudence.
I am not so sure about that, Mr. Courtney. I thought that Justice Balcom was much more nuanced in his treatment of Vega, possibly because of what I said earlier, that he was bound by that decision unless he could come within one of the three exceptions. And so I thought he gave reasons as to why Vega was distinguishable, rather than saying that it was not good law.
Yes, I stand corrected, Your Honor. I'm obliged.
But you see, Mr. Courtney,
I put it more strongly.
No, but that's okay. But you see, you need to put it strongly, because if this case has to be decided, there being no defense, there being no evidence, if this case has to be decided as a pure and absolute question of law on the admitted facts in the statement of claim, that's what this case has to be decided on, agreed?
Yes, Your Honor.
Then Vega is a hurdle, isn't it?
Your Honor, yes, it is a hurdle.
All right. So Vega on the undisputed facts has to be faced. I think that's why I say I agree with you.
For the respectful note that I made was that it's a threshold question.
Well, or there you go. So that's why I tell you I agree with you. So,
Mr.
yeah.
Courtney,
Yeah,
if I
yes.
may, there's something.
Yes.
Did you finish your submissions on the? You started a proposition that on what basis would someone who paid $2,000 for a piece of land they knew was granted to somebody else come back later to make claims for $2 million? And then you say the courts may have an enabling time. Did you finish that submission? One. And secondly, if you haven't, please do. I'm interested in that. And secondly, when you say, does that theory of courts enabling, would you bring Vega into that as well? Those are my two questions. Thank you.
Mr. Courtney, before you answer my brother, I'd invite you to be very careful
Yes,
in
of course.
your answers, because I do not know whether all the parties who could be affected by what you say are before the court. And I just want us to be exceedingly careful with that line of inquiry. I think that what concerns us can really be answered by our analysis of the Vega decision and whether it was good law or not, without or getting into any other questions which may affect persons who are not before us.
Mr. President, I am interested in that question. Mr. Courtney is a very senior lawyer. He would know how to answer that question. And here we are dealing with a question of justice in this matter. If he can, I'm sure he will know how to handle delicate questions put before him. That's why when I told him whether he had more to say, it's up to him.
Your Honor, Mr. President, I think I can respond without at all impugning anyone.
Thank you.
What I meant, and perhaps enabling is the wrong word. Let me start by saying it. What I meant is the following, Your Honors. And for this, we have cases in our submissions showing the difficulty that the government faces. If you have, and this is a hypothetical, a person agrees to sell a piece of land to another person, and there is let's say a down payment is made, there is a breach. This vendor cannot perform or does not perform. You commence a claim for specific performance in the alternative damages. The court then makes a determination, I am going to order specific performance, or in the circumstances of the particular case, I will not exercise my discretion and order specific performance. I will go to damages. On an assessment of damages in those circumstances, the established law is that the purchaser is entitled to the value of that land less the cost, the purchase price. So that if there is an increase in the value of the land, he or she gets that value because that is the opportunity that has been lost. They would have bought a piece of land, the value of which have appreciated. What we have here, as we have in many other cases alluded to, and what I was referring to, Sir Justice Ibo Suji, is the court dealing with a situation where the government does not have title, entering or issuing a grant to someone, thereby creating the impression that I have entered into a contract of sale with you, I have given you title. The second grant is then discovered and you come to court. What the courts in Belize have been doing is to say that that second grant is in fact a contract between the two parties. And because the government doesn't have the title, I can't order specific performance. I must do damages. And then they use the orthodox methodology, value the property, and give it to the person in terms of damages. What we say with respect is that the proper analysis where A does not have title, it is impossible to perform. And because it is impossible to perform, the law is that no contract was constituted between the parties. I cannot agree, as I sit here, however solemnly I sign it, agree with Ms. Matut that I'm selling her Buckingham Palace. I don't care how it can have 10 stamps, it can be witnessed by witnesses. Because I cannot, it's not my property, there is no contract.
And what makes the difference? What makes the difference there, as I understand you, would be that the purchaser in that case would not have been a purchaser of a value without notice. Is that your argument?
Well, on the facts of this case, that arises, but whether you have notice or not, Your Honor, my respectful submission, and we rely on Hallsbury for this, my respectful submission is it is impossible for two parties to agree an impossibility. That is not a contract. And in the circumstances where, for example, A agrees to, let's do a hypothetical. A person whose father dies, the father owns land. The son believes he was going to get the property from the estate. You enter into the agreement. It turns out that in fact the father had left a will, it belongs to someone else. I cannot give you title. I never had title. There was no contract. In those circumstances, the appropriate remedy, as it is in this case, is not damages, but restitution. If the person has paid a deposit, give them back their deposit with interest, so that the person is paid for.
I think I follow you very clearly and I find an objection with much of what you've said. What though, to take the hypothetical further, you do have a purchase of a value without notice. And that person has then, in reliance on the sale of the land, committed himself, herself to other contractual obligations. Is it simply a matter of restitution there, or are there other remedies which may become relevant depending on what has happened since that quote-unquote contract?
Your Honor, I am fully aware that there are consequences. And this is where we get back to the fundamentals. If it is that there's a second grant and therefore there is no title, the person is a bona fide purchaser for value without notice, goes to his or her bank and takes a mortgage. The bank is obliged to search the very book that Your Honor identified. The bank is obliged to search the judgment's book to ensure that there's no judgment. You are obliged by law to go and check the register, if it's registered land, to see whether or not there has been some prior transfer or some dealing with that land. The consequence then is whether a proper search was done and who is to blame. In the case of a bona fide purchaser for value and a subsequent person, you have to look at the facts at that time as to where the breach would lie. So none of that, in my respectful submission, Your Honor, because of that consequence which has to exist, could ever mean that the prior title is now valid.
No, I hear you there.
So,
but
Your Honor, I'm agreeing with you that there are consequences from it, and each one has to be dealt with on their own fact and the appropriate remedy granted.
Yeah. Okay. Thanks.
Your Honor, I wish at this stage to frontally address the question of the challenge to what is called the liability order. And I do so, Your Honors, by making the following submission and relying on the law. A lot was said by my learned friend without reference to any cases or any learning. And I'm going to ask the court to turn up the case of Strahan, pronounce that correct?
Strawn.
It's at page, it's tab 14 of my learned friend's submissions and reply. Is the court there?
I wouldn't detain you. I'm not there myself, but please.
Your Honors, this is the Judicial Committee of the Privy Council, and I ask you for purposes of your note, make a note of paragraphs 11 and 12, and I just very quickly
Yes.
read what is mentioned there. In 11, in his judgment, Justice of Appeal Panton stressed that the order of Walker J had never been appealed. He observed that although the foundation of the plaintiff's case consisted of an attack on the validity of his order, no appeal from it was before the court. This, just anecdotally, he observed that there had been many cases in the Supreme Court in which default judgments had been set aside even after damages had been assessed, and said that he would be very hesitant to classify as a nullity an order made in the circumstances that face Walker J. The next paragraph, Justice of Appeal Cook, he agreed with Justice of Appeal Panton that applications to set aside default judgments for liquidated damages after default judgment of damages to be assessed were commonplace in Jamaica. I just want to say that anecdotally. The two paragraphs which I rely on are 16 and 17. Paragraph 16. In their lordship's opinion, these questions are easily answered if 3 points are borne in mind. The first is that once judgment has been given, whether after a contested hearing or in default for damages to be assessed, the defendant cannot dispute liability at the assessment hearing. I repeat, at the assessment hearing. If he wishes to do so, he must appeal or apply to set aside the judgment. While it stands, the issue of liability is res judicata. Second, whether the defendant appears at or plays any part in the hearing to assess damages, the assessment is not made by default. The claimant must prove his loss or damage by evidence. It is because the damage were at large and could not be awarded in default that the court directed that they be assessed at a further hearing at which the plaintiff could prove his loss. The third is that the claimant obtains his right to damages from the judgment on liability. Thereafter, it is only the amount of such damages which remains to be determined. This is precisely what Justice of Appeal Jamadar was raising with my learned friends. Paragraph 17. Accordingly, it cannot be said that a judgment, whether after a contested hearing or by default, for damages to be assessed is spent once damages are assessed. It remains the source of the plaintiff's right to damages, nor can it be said that in such a case, the interlocutory judgment is overtaken or superseded by the final judgment for a liquidated sum. It would be more accurate to say that it is completed and made effective by the assessment. By entering final judgment for the amount of the damages awarded by the jury, Justice Bingham gave combined effect to the default judgment on liability and the quantification of damages by the jury. I pray in aid these paragraphs.
So, Mr. Courtney, if we can just come back to a kind of a first principles thing, I raised it with Mr. Barrow. This is a classic case of splitting a trial, right?
Indeed.
But it's one trial. The claim was for liability plus quantum damages to be assessed. Nothing changes that. The fact that you managerially split how you do it. Take a benign example. You on a case management conference, you state a preliminary issue to be decided, right? You hear and determine the preliminary issue. It may not resolve the whole case, but it may. It does not change the fact that it is part of a single case going forward. So as I tried to raise with Mr. Barrow, I mean, the authorities are there. Chief Justice De La Bastille in Trinidad has raised this extensively, and certainly in our local courts. And as far as I'm concerned, there is a single matter with a single cause with different relief. And what has happened in this case is the damages relief went forward, right? So for myself, under the 205 in the Supreme Court Act, in whatever it is in Belize, apologies. So I don't see that there, for me, I don't see a conceptual problem, right?
Your Honor, sorry, I was just, sorry.
No, please go ahead. Please, after you.
No, I was just saying I was seeking to make good the point that insofar as there is a split, however the split arises, once that final judgment and assessment of damages is completed, it creates a composite judgment because
for which there's a right of appeal.
Your Honor,
understood.
Well, obliged.
Yeah.
The further point, no, and this is bringing it home to this case, further point I wish to make is my learned friends have relied on the case of Lunon. And again, Your Honor, it's at tab 13 of my learned friends. Respond submissions and reply.
Please don't lose your place. You're going to go to Lunon. But just before you do that, I was trying to think about what Mr. Barrow was saying, because if I understood him correctly, it is not so much that the judge said the damages are at large and you must, go and assess the damages, right? Wasn't the concept of market value mentioned, and wasn't the idea there that the assessment was related to the identification of what the market value was, as distinct from the whole question of damages at large?
Your Honor, just I tried to address that earlier when I used the word enabling, when I said that what the practice in Belize in these circumstances, where there's a quote unquote second grant, is to use the orthodox methodology, which is to do the market value of the property and to pay to award us damages, the market value of the property less the purchase price. So that is what the judge says. In these circumstances, damages are to be assessed on the basis of the market value. That is what would happen in the ordinary breach of contract for the sale of land. It's an orthodox analysis.
So you're saying we would basically have to go behind the order made by the judge?
Well, I don't know.
Because if we stuck with that, then we are simply trying to ascertain what was the market value. But you're saying that is bad law, right?
And this brings me to the point that I was seeking to make, which is when one asks yourself, what is the measure of damages in this case? One has to ask yourself the measure of damages for what? What Justice Farnese did was to assume that there was a contract by the second grant, that the government was in breach of that contract, and therefore damages are to be awarded. My respectful submission is, and I'm asking this court, inviting this court, because it is essential on the assessment, the damages order. This court can only grant, and any court can only grant damages in respect of an identified breach. For there to be an identified breach, there has to be a contract. My respectful submission, relying on Hallsbury, is that at the time of the second grant, there was no title in the government to give to Mr. Ramirez, and therefore he knowingly went and got this second grant. And having been warned by the president, I won't say why.
I was
I say,
going to warn you again.
I say, no contract was consummated, and therefore no breach. What occurred is a nullity, and the proper order is restitution.
But
Your
Mr. Courtney, I mean, I don't want to go back to it, but you see that you say you can't have two, the legislation says you can't have two deeds for the same piece of land, fair enough. But does it also say that the fiat is prima facie proof of title?
Yes, Your Honor.
So if somebody searches in the register and they see their obligation on the face of it, you don't want to talk about the enabling, so we're not going there as yet. If somebody in the due discharge of the requirements under the law goes to the register and sees a document, and a document is on the register, the same law that says you can't have two, good law, also says that the register is prima facie and absolute proof. It's like a torrent system in a form, right?
With respect, Your Honor, what it says is that is evidence of title.
Yes.
But it is subject to the fact that, in fact, when you look at it, government did not have title, and therefore.
But you see, I suppose that's what I keep coming back to in my mind. I agree. If the document is in fact not evidence of title, fair enough. How your statement is, because two are disclosed in the statement of claim, the assumption must be the latter is not proof of title.
No, Your Honor. No, Your Honor. I say, under the law,
yes,
Section 17, read with Section 2, the conveyance, the grant originally transferred the fee simple estate in that land to Palmen Pleasure Cove.
205.
That is a fact. That happened.
Yes.
The issuance of another Fiat grant cannot do the same thing. It simply cannot convey fee simple estate to Mr. Ramirez.
Because the grantee, or the grantor rather, doesn't have
title
that to grant. So you cannot give what you don't have.
Yes, sir.
So is it the case then that the theory of that legal impossibility you are talking about also goes to the quantification of quote unquote damages?
It goes
because you cannot quantify the value of property you never had. So that quantification cannot give you a value as a claimant. Is that I mean, I've muddled the thought there. You know what I'm getting at?
You are absolutely correct in my respectful submission. And Your Honors, I want to make this point. Because I think
before you keep that point, don't lose it, please. Don't lose that point. I want to finish that. So in that scenario, is it your argument that the best that could possibly happen would be to find out the value of $2,000 at the point where the person paid for it. What is that value, current value, and then give it to that person? Would that be what you're arguing at?
And interest.
And interest. Thank you. Now,
Your Honor,
please finish your point.
the point I wanted to make, and I ask the court to bear this in mind, all of this analysis applies to a sale between two private individuals. If it is that a private individual can sell his land more than once, we have no system of land law in this country. If the government can sell its land more than once, we have no system of land law in this country. So, Your Honors, it is my respectful submission, and I was referring to the Lunan case, because what Lunan directs the court's mind to is that on an assessment of damages, one is obliged to look at the cause that created the damage for which compensation is given. Which is why, and I heard my learned friend, Mr. Barrow, on my submissions in the Court of Appeal. What I was saying in the Court of Appeal and what I say here, you cannot look at the assessment order without asking the prior question, what are you assessing damages for? In this particular case, it was for supposedly a breach of contract. You must ask yourself, which contract? What was it? And Your Honors, this forces me to take the court to the order of Justice Farnese. Your Honors, it appears on page 126 of the record. Your Honor, after this, I will turn with your leave to the question of the notice to vary.
Yes.
Your Honors, I just want to examine this document and to remind the court what happened. A defense was filed to the statement of claim. The Andre Vega decision was handed down. The Andre Vega decision, among other things, held that the second grant is titled. The application was made, which is on page 122, for the defense to be struck out. And I don't want to press too or rely too heavily on this, but the rules cited was 1.1, the overriding objective, 26.3, the case management powers, that there are no reasonable grounds you can strike out a pleadings, and part 16, assessment of damages. For what it's worth, none of these rules that were relied on empowers the court to enter judgment, but I don't make too much of that. There was no affidavit evidence in support of this application because Mr. Lindo went to court with his ACE card and said, here is a Court of Appeal decision just handed down, binding on you, Justice Farnese, that says my client has good title. Now, Your Honors, she is asked to strike out a defense that disputes that the second grant is good. She is persuaded that the Court of Appeal decision in Andre Vega means that the second grant is good. Mr. Ramirez went to court with a grant and a Court of Appeal decision that says you have good title. That was his remedy. That's what he wanted. specific performance in the alternative damages. He gets a Court of Appeal decision that, in my words, approbates his title. But he doesn't ask the court for that. And when you look at the order, and this is why I say it's curious, the defense is struck out. Judgment is entered in favor of the claimant. And I pause here to say, relying on Lux, that is not a judgment because that cannot be enforced. That is nothing. Goes on to say there must be compensation on the basis of market value. Now, bear in mind, this is giving you compensation for a title which you're holding, which a Court of Appeal says is good. Third order, the claimant is to surrender minister's fiat grant to the government. I am telling you to surrender your good title to the government so that the government will compensate you in the millions of dollars for a good title. Your Honors, all I will say, something is fundamentally wrong with a statement of claim where a party comes to court and says, I have a minister's fiat grant and I want specific performance of that. Order the government to give me title and you have it in your hand. Something is fundamentally wrong for a court to say. The Court of Appeal has pronounced that a second title is good, so I strike out your defense. And to go beyond that and say, but the government must compensate you in millions of dollars. It is illogical and cannot be explained. Your Honors,
Mr. Courtney, hold on. Let me ask you something on this because I'm seeing this as you pointed out. I just want to understand. So you're saying the seeking relief for an order on the statement of claim, an order for specific performance is suggestive that the statement of claim itself has an admission of what? A lack of title? How would you frame that in terms of title? How would you kind of frame that? Because of course they assert title, right? Their paragraph, what is it now? The paragraph which pleads the 2019 thing. They purport to plead the fiat, right?
Your Honor,
Paragraph 10, right?
when you when you investigate 10 and 11 of the statement of claim,
yeah,
only the claimants could explain it to you.
But no, yeah, but I'm asking you something. In other words, are you saying that given the relief for specific performance, let me ask the question then, how does the relief for specific performance configure with a clear assertion of title? In other words, if it is that on the statement of claim, on its face, the assertion of title is equivocal, you understand what I'm saying?
Yes.
Then for me, that is, I'm curious to hear how you respond to that.
I struggle to explain it, Your Honor. I struggle to explain it. Here we have a situation where Mr. Ramirez and the government are aware that the government doesn't own this land. Nevertheless, the government says, I will rectify. And what is curious, as Madam Justice Rajnath Lee pointed out, the rectification was merely in relation to the survey number of the survey plan. But what in fact happened, the minister ordered the grant to be canceled and a new grant issued. And so a claim was then brought on that second grant.
All right, sorry to interrupt
In
you.
the pleadings-
Continue what you were saying. I didn't want to stop you. You were saying something that was very important for us. So sorry about that. Yeah.
Yes,
Thanks.
I was just trying to pull together the threads of the submission on this part and then turn to the notice to vary. I was just saying, Your Honors, with the greatest of respect, our fundamental submissions are the following. One, the second grant is incapable of creating a contract between the parties. It is absolutely impossible. It is made worse on the statement of claim, where it is admitted that Mr. Ramirez knew and the government knew that title had already been sold. So there is no purchase of a value without notice. This is a quote unquote purchaser with notice. In those circumstances, Your Honor, it is our respectful submission that a contract was never concluded, and we say that the appropriate remedy is restitution. This is why, Your Honor, the order of Madam Justice Farnese, in my respectful submission, is difficult to understand if it is that Andrew Vega says the second title was good. Your Honors, before I run out of time, I want to address the question of the notice to vary. And I mention again that you will note that the appellants have not cited a single case on the notice to vary. Your Honors, the notice to vary was filed pursuant to Order 2, Rule 5. Order 2, Rule 5 gives an unconditional right to a respondent to file a notice to vary, alleging that the judgment should be varied. We exercise that right unconditionally on time. Now,
Mr. Courtney, this is where I had a little problem, because I thought that is what perhaps the notice ought to have mentioned, but it mentioned Rule 7, Order 2, Rule 7.
Your Honor, I think before the Court of Appeal, I mentioned that that was just a typographical error.
All right, but I'm not sure that was mentioned here. There is a Rule 7, of course, which is also relevant in terms of the timelines for the notice. But when they're talking about intention to vary the decision, that is a specific reference to Rule 5, which I
Yes.
thought it was strange that you didn't have it here.
We relied on, so as I said, that was a typographical error. We relied on 5. And I don't think my learned friend, Mr. Lino, took our point when we were in the Court of Appeal, that it was
Okay.
5 and not 7. And Your Honor, my
But
submission.
you admit it was 7 here before us and not 5.
7, Your Honor, is a preliminary objection. We are not relying on a preliminary objection.
I thought 7 had to do with the procedure, no?
No, it says 7 says a respondent intending to rely on a preliminary objection to the hearing of the appeal should give 3
Right.
clear days notice. We relied on
Yeah,
5. If a respondent intends upon a hearing of the appeal to contend that the decision of the court below should be varied, he shall within 14 days after service of the notice, or within such time as may be prescribed by a special order, made an application, give written notice of such intention to the parties.
Yes. No, that was the one I thought applicable. I was just misled by
Yes.
reference to 7. Yes.
No, Your Honors, I say Rule 5 gives the respondent, where an appeal has been filed, an unconditional right to file a respondent's notice within 14 days, which we did. My learned friends have cited the last authority, Rule 2. Rule 2 is telling. Rule 2 says, where an appeal lies by leave only, any person desiring to leave shall apply for leave within 21 days. That's 2.1. 2.2, if leave is granted, they should do certain things. 3, 2 subsection 3. If a respondent intends, upon the hearing of an application brought under this rule, to apply for leave to appeal in order to vary the decision of the court below, he shall, within 7 days of the service upon him of a summons or notice, give written notice of such intention to any parties who may be affected by such contention. And in such notice shall state clearly the reasons on which he intends to rely, and within the same period he shall file a copy of such notice with the registrar. If on hearing of the motion or summons brought under this rule, the respondent is given leave to appeal in order to vary the decision, he shall be exempt from 5. What Rule 2 speaks to, Your Honor, is if the appellant requires leave to appeal, then a respondent who wishes to file a respondent's notice must also seek leave to appeal, to file the notice to vary. What Order 2, Rule 5 speaks to is where an appellant has the right of appeal as of right. The respondent is entitled as of right, without seeking leave, to file the notice to vary. It is obvious in this case that the appellants filed their notice of appeal as of right without leave. Rule 2 does not apply. They did not apply for leave. It is my respectful submission, Your Honor, that we are entitled to have filed the notice of appeal as of right. Your Honor, can I take the court now very quickly to our authorities? None of which.
So, sorry, because you say you come within Rule 5, then the remedies available under Section 205 would kick in. Is that what you're saying? That the court would have all of those remedies it could award?
Absolutely, Your Honor. And
Okay.
as you asked the question of my learned friend, I disagree with his submission to you. Your Honor, we have cited authorities which in my submission, my respectful submission, speak to the status of a notice to vary. Your Honor, at tab 9, we cite the case of Fred, a decision written by a judge by the name of Barrow. In the interest of time, Your Honors, I won't go through that judgment, but it supports in my respectful submission our contention that once a notice of appeal has been filed, the jurisdiction of the Court of Appeal has been engaged, and therefore the respondent is not limited in terms of what he can challenge on a notice to vary. And I just read one paragraph where the same contention of my learned friends was made in this case. And this is what Justice of Appeal Barrow, as he then was, said. In addition, if there is no limitation in CPR 2000 on the scope of a counter notice, as the solicitors for Mr. Schultes submit, then I am at a loss as to the basis on which the solicitors can ask the court to impose the limitation that they seek to impose. I see no merit in this aspect of the application, i.e., because the party who appealed on a specific issue and the counter notice joined issue on that, but also raised another one. The contention was that you can't do that because I only appealed on costs. And the court, Mr. Justice Barr says, when you look at all the equivalent, our Order 5, it doesn't limit the scope of a respondent's notice.
What paragraph is that, Mr. Courtney?
18.
Thank you.
Your Honors,
my colleague had raised with your friend the issue that once there was an appeal, you could join issue with that appeal, even without the notice. How do you respond to that?
Your Honor, and quite honestly, that is often done. And the rule goes on to say you give the other party time. If you need time, I will allow you time to respond to it.
Yeah.
Your Honor, KMG, which follows FRET and applied FRET, I read very quickly at paragraph 9. KMG argues in essence that even though the CPR would not work practically given the timelines for the filing of a counter notice and the service of a notice of appeal, the CPR cannot derogate from the law. Paragraph 11, Mr. Moverly Smith argued to the contrary. Paragraph 15. This is a decision of the Court of Appeal of the Eastern Caribbean. It refers to, well, it says the decision of Malitsky is at variance with the decision in FRET, which I just referred to, and was not the subject of the detailed analysis, as it was not a point which appears to have been taken or the subject to any arguments put forward thereon, whereas in FRET, the point was fully argued and carefully considered. To our mind, the approach adopted by Barrow, Justice of Appeal Barrow, is a correct approach, and we adopt his reasoning that it should not matter in the case of a counter notice that it is a counter appellant and not the appellant who has placed the other issues before the Court of Appeal. Once an appeal has been commenced, whether as of right or with permission, it does not matter what it is the counter appellant. It does not matter that it is, the counter appellant and not the appellant who has placed another issue or other issues which has been the subject of a judgment or decision on the appeal before the court. The leave granted to KMG to appeal the judgment and KMG having launched an appeal pursuant to that leave enables a counter appellant to cross appeal on an issue which was the subject of that judgment without necessitating the counter appellant seeking separate permission. And it is for this reason, Your Honors, that I took the court to Strahan to show that the liability judgment and the assessment, the damages judgment effectively becomes one, and you can't separate them. Your Honors, in the interest of time, and I strongly commend paragraphs 17 and 18 of this decision. In the interest of time, I won't read it. Our submission is on these two cases, and I just want to refer to one further case, Your Honor. On these two cases is that, one, the notice to vary was filed as of right pursuant to Order 2, Rule 5. 2, there's no limitation on the scope. And 3, in this particular case, where, and I use this word loosely, where the liability judgment and the assessment judgment were merged, it is entirely open for a respondent on a notice to vary to raise the issue of the liability judgment. Your Honors, the final case I wish to invite.
What merges them? Sorry.
Somebody's mic is open.
Yes.
That shouldn't be. Yes, please.
Your Honors, the final case is at tab 16. It's the case of Gerlach. It's from the High Court of Australia. It's dealing with the same issue, Your Honor, but I want to urge on this court a test that is used in this case. In this particular case, it was a case for libel. A party who brought the claim wanted trial by jury. And all the administrative steps were made for that. Just before the hearing, the defendant applied to a judge to say, no, trial by judge alone. The judge made that order. It went to trial before a different judge as a trial of judge alone. Judgment was given against the defendant and they appealed. And on appeal, they now, of course, seek to challenge the order that was made by the different judge that it should be trial by judge alone. At paragraph 4 and 5, they state the obvious. In the course of trial, even before the trial commences, interlocutory orders may be made which affect the substantive rights of the parties. Rulings that are made in the course of trial about what evidence will be admitted are an obvious example. To adopt a rule that precluded challenging an interlocutory order except by an appeal against that order would provoke unnecessary multiplication and fragmentation of proceedings. It is not surprising then that in at least some circumstances, a party may challenge the correctness of of the final judgment entered in a matter on the ground of some interlocutory decision was wrong. And Your Honors, I pray in aid this paragraph 6. The proposition that any interlocutory order can be challenged in an appeal against the final judgment in a matter is often stated in unqualified terms. The better view, however, is reflected in the formulation adopted in Spencer, Bauer, Turner, and Handley, where it is said that, quote, on an appeal from the final order, an appellate court can correct any interlocutory order which affected the final result. So it is our respectful submission, and this is whether you put in a notice or not. If on an appeal, there is an interlocutory order which affected the final result, it is our respectful submission that the Court of Appeal has jurisdiction to deal with that issue. Your Honors, if I ask you to make a note, the court then went through, beginning at paragraph 43, the Privy Council practice, and it cites cases that we rely on. And then it says the Australian practice starting at 48. Again, Your Honors, in the interest of time, I don't wish to read these paragraphs, but we rely specifically on paragraphs 48 through 51. And the essence of these paragraphs, is that in order to do justice, there may be interlocutory decisions that affect the outcome of the case. The Court of Appeal has jurisdiction to correct any error that is made. Paragraph 51, it says, reasons of authority, principle, and policy therefore combine to support the conclusion which a Court of Appeal reached in this appeal, namely that it had jurisdiction to deal with the order, the interlocutory order that there should be trial by judge alone. Your Honors, I would like to sum up. We say the second grant upon which this case rests did not create a contract, as performance was impossible, as title had passed as long ago as 2005. It is aggravated in these circumstances where the pleadings show that the minister and Mr. Ramirez were well aware of this. Secondly, we say that the respondent's notice was filed in strict compliance with the rules, that no leave was required, and we were entitled to invite the Court of Appeal to consider whether or not there was in fact a breach of contract. And if there was no breach of contract, because there was no contract, to order restitution. Your Honor, applying the application test, and we put in the case of Belgrave as authority for that, the liability order was interlocutory and therefore could have been challenged on the damage along with the damages order. It is our respectful submission that Madam Justice Farnes erred in one, being persuaded by Andre Vega that title was good in the second grant, to then go on to make an assessment of damages and to award $2 million for a breach of contract. We respectfully submit that where there is no contract, as in this case, arising from the second grant, the appropriate remedy is not damages, but restitution, and that Mr. Ramirez should be paid back his $28.70 with interest on it.
Mr.
Mr.
Barrow raised the issue of
Go on.
costs, etc., that her client may have been exposed to. You have a view on that?
Your Honor, this is a very, I will use the word I used before, curious case. Because it was commenced with knowledge, with specific knowledge that the government did not have title, we respectfully say that the government is entitled to its costs.
Very well. Thank you. My brother, did you have a question?
I do, and that was on the last proposition Mr. Courtney spoke to, which relates back to my interrogation with him before. You rest the argument, Mr. Courtney, on legal impossibility. But we also had Ms. Barrow and Mr. Barrow. Ms. Barrow, in his capacity, he testified, I use that expression advisedly, about how he found a mess in the land registry, and he didn't want to deal with it. But on that question, that this seems to be a prevalent difficulty, multiple grants of fiat in respect of the same land, is there an argument of public policy as well to your case, Mr. Courtney, about you can't have government paying these damages to multiple people over grant of fiat to the same land, because those damages come out of public purse. Is it the case? Is there a public policy argument there as well?
Briefly, if you could, please, Mr. Courtney.
Your Honor, I was just trying to find the note where it is. In our written submissions in the court below, we specifically raised the public policy issue and said that there is a live public policy issue here that this court needs to address.
Thank you.
And
Thank you.
our submissions are in the record, Your Honor.
Thank you.
Thank you, sir.
I'm obliged.
Thank you. Thank you very much, Mr. Courtney. Mr. Barrow, you have the right of reply if you wish to exercise it.
I certainly do.
Okay,
I most
bear in
certainly
mind that it's 15 minutes maximum for that right, please.
I am guided, Mr. President. I want to take up from one of the last points my learned friend made, which relied greatly on the fact that the liability order is an interlocutory order. I want to repeat the submissions I made earlier, that on the basis of the authority of the 2005 Privy Council case of Vehicles and Supplies Limited and another against Financial Institution Services Limited, it's at tab 1 of our first set of written submissions. The board found, and I quote,
Because
a summary. I'm sorry. I'm sorry?
Sorry.
No, please proceed.
The board found that, and I quote, a summary judgment in proceedings in which a defendant appears and offers a defense, but the defense is held to be wholly defective, is a final judgment on the merits and gives rise to estoppel per rem judicatum. We make the point as well that in the 2008 Court of Appeal decision, Court of Appeal of the Eastern Caribbean, in Antigua Commercial Bank against Martin, and that is tab 2 of our written submissions, the ratio or that proposition of the Privy Council was in fact adopted and applied. recognized, approved, if you will, there was a difference on the facts, because on the facts of the Antigua Commercial Bank case, the order was an interlocutory order. It was a default judgment, as opposed to the type of judgment that the Privy Council described in Vehicle and Supplies, which is not an interlocutory judgment because it is a summary judgment. In this case, it was a judgment after a strikeout application, part 26, which deals with strikeout applications, and part 15, which deals with summary judgments, mirror each other. So there is no distinction of any substance where the learning is concerned. A summary judgment or a judgment entered on a strikeout application in proceedings in which a defendant appears and offers a defense, but the defense is wholly defective, is a final judgment on the merits and gives rise to estoppel per rem judicata. So, Your Honors, I know certainly, with respect, Mr. Justice, Jamadar seems to be inveterate in his position that it really doesn't matter. At the end of the day, the Court of Appeal had jurisdiction to entertain a challenge to the liability order. But at the risk, maybe I'm put in mind of this because of Mr. Christopher Nolan's bringing the Odyssey to film. But perhaps it's a labor of Sisyphus on which I'm engaged when I insist on trying to convince the court that there is a critical distinction to be made regarding this question of final versus interlocutory, and that in the circumstances of this case, the order of Farnese, of Judge, Madam Justice Farnese, the learned trial judge in the first instance court, is a final order from which an appeal would have lain in the ordinary course. It is not competent. There is no capacity for my learned friends to raise that by way of their cross appeal, which only comes into being because of the appeal of the claimants, appellants, against the quantum of damages at the assessment proceedings. So that's the first point. I really do stick to that. Secondly, even if the liability order was an interlocutory order, in my respectful submission, there cannot, the argument that at the end of the day, an appeal or a counter appeal, a cross appeal, in the appeal that arises at the instance of the claimants who are dissatisfied with the quantum of damages, even if the liability order which preceded that assessment was an interlocutory order based on our rules, you cannot, in a cross appeal to the finding as to quantum, in a cross appeal regarding the damages order, you simply cannot raise the liability order except that liability order had been set aside. Once that is left standing, and the very cases, some of the cases that my learned friend cited, we have in common. The Lunoon case makes that absolutely clear. I think my learned friend quoted from it and from Lord Justice Peter Gibson, who said at paragraph, who said, and I quote, "It is not in dispute that when judgment in default is entered for damages to be assessed, The question of liability is thereby determined and cannot be challenged while the unappealed judgment still stands. Lunun and Lord Justice Gibson are quoted in the supplemental authority that we sent to this court maybe 2 or 3 days ago. And that is the case of Dipcon Engineering Services Limited against Bowen and another. And in that case,
Your Honors, I hate to do this, but my learned friend has relied on, this is now the 3rd case that I have not made any submissions on. He's not replying to me.
No, you did make submissions on the Lunun case. You did make submissions on
Yes,
this
we
Trackland
did on
case.
that one, yes.
I made no submissions on Pickers and Supply. I made none on Antigua Commercial, and I made none on Dipcon. He is not replying to me.
All right, thank you, Mr. Courtney.
If I may continue?
Please, Mr. Barra. Yes, please continue.
Yes. Dipcon merely replicated the learning in Lunun and perhaps expanded on it a little. There, the Privy Council was dealing with the question of whether, and this appears at paragraph 20 of the decision, whether it was open to the Court of Appeal to set aside the default judgment on an appeal against the assessment of damages. Again, dealing with a default judgment, which was clearly an interlocutory judgment, not as in this case, as we are claiming, a final judgment. And the Privy Council found that contrary to what Mr. Henriquez, counsel, had suggested, relying on Alpine Bulk Transport Company and Saudi Eagle Shipping Company, that it could not accept that argument. Whilst the board said at paragraph 24, Saudi Eagle is clear authority if authority were needed for the proposition that an application to set aside a default judgment can be made and if refused can then be appealed, notwithstanding that final judgment has subsequently been entered, it is certainly not authority for saying that on an appeal against an assessment of damages, a previous even default judgment can be set aside without any such application ever having been made. Or as here, that a previous refusal to set aside the default judgment can be challenged without that refusal being appealed. As to Gerlach or Gerlach, I'm not even sure how you pronounce it. Your Honors, the question is that in Australia, there is, and if you look at its page 1006 or 135 of the records, and paragraph 7, it is necessary to make the qualification, the court says, which affected the final result, at least to reflect the well-established principle that a new trial is not ordered where an error of law, fact, misdirection, or other wrong has not resulted in any miscarriage of justice. That principle, well established in common law, is applied to appeals to the Court of Appeal of New South Wales by Part 51 AA, Rule 16.1 of the Supreme Court Rules 1970. That rule provides, and it sets it out. Gerlach, therefore, is based on common law to some extent. There was, before that, the old 19th century case of Singh, but it's been codified. Our position is that whereas here there is codification, there is no room, there is no space for saying that interlocutory rulings may be ignored in terms of no appeal being taken, and the victim, the person that loses the interlocutory ruling, can wait until the end when that person is appealing generally against the result of the case to bring back in scrutiny of the interlocutory ruling. we had said in our reply submissions at paragraph 9, it is well established that it is a loser in relation to a judgment or order or determination that has to be appealing if the court is to have any jurisdiction at all.
The authority is there.
The authority is the let me just find it. I'm not sure how I'm not sure how we pronounce this, Your Honors. The case against the government of the Russian Federation and others, it's C. Noga d'importation. I better stop before I break my tongue.
Yeah, those are always challenging. Mr. Barrow, we have a very short period of time left for you. Couple minutes, could you wind up, please?
I just want to wind up by correcting the record, correcting something that my learned friend, Mr. Courtney, says. He insists that the strikeout application was not by consent. And indeed, the order of the trial judge framed it in view of the application made by Mr. Lindo and the non-objection of the defendants. But if you look at Mr. Courtney's written submissions at first instance, it's page, the government submissions at page 136 of 278 of the record, the written submissions on behalf of the defendants at paragraph 3. The defendants, they say, the government, the defendants said, the defendants filed their defense. However, on the 23rd day of January 2023, the claimants made an application to strike out the defendant's defense. Eventually, the parties consented to the application. That's what the defendants themselves say. So with that correction, with that correction to the record, Your Honors, I will leave it there, just reiterating finally that a consent order may be set aside in exceptional circumstances. That was what would have been required here before the interlocutory order, which was not the interlocutory order, I'm sorry, the liability order, which was by consent, could have been raised in the cross appeal. Thank you, Your Honors.
So, President, may I have 1 minute to reply to DIPCON and to vehicles and supplies?
1 minute, Mr. Court.
1 minute. Your Honor, in relation to DIPCON, I say the following. It is distinguishable because when the court comes to reading DIPCON, you will see that there was no appeal. The order in question was not appealed. In this particular case, we have appealed. At paragraph 15 of the judgment, in any event, the Privy Council said that type of procedural point is irrelevant. The court would easily have granted, and the Court of Appeal would have granted an extension and allowed the point to be made. In relation to vehicles and supplies, Your Honor, with the greatest of respect, vehicles and supplies, the res judicata arose because at the High Court, the court found that vehicles and supplies had no real property interest in the lease. They did not appeal it to the Court of Appeal. When it came to the Privy Council, they sought to raise it, and the point was made, res judicata, you have not appealed that point. That is absolutely not what is happening here. We have appealed by our cross appeal on the issue of the liability and the damages. Oblige, Your Honor.
Thank you very much. And we allowed him because, according to Mr. Courtney, he had not discussed those cases in his primary submissions. I must say that the primary submissions went on for a while, and therefore some of us may have missed some of what was discussed and not. Did I hear somebody wishing to intervene? No? Okay, so I want to, on behalf of my colleagues, thank you both for very stimulating, learned, erudite submissions, very clear. And of course, we will take them into consideration, and also, of course, their written submissions. We'll, of course, reserve the judgment, and as soon as we are ready with a decision, we will notify you, as has become our practice recently. We will notify you as soon as we are clear when it is that we can give our decision. Thank you very much indeed. Madam Deputy Registrar, would you please close the proceedings?
Certainly. Thank you, President Anderson. Thank you, Madam Justice Rajnatley. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Udano. Thank you, Mr. Justice Ibusuji. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good afternoon to all. Thank you very much.
Oblige, Your Honor.
Thank you very much.